be arriving shortly. So good afternoon to everyone. Thank you for being here to engage in a very important public discussion and evaluation of the state's employment discrimination laws. Last year marked the 50th anniversary of the Fair Employment and Housing Act and the Department of Fair Employment and Housing. This state agency was originally created by the legislature in 1959 as the Division of Fair Employment Practices to combat employment discrimination. Prior to the Fair Employment and Housing Act, its predecessor, the Fair Employment Practices Act, and the Fair Employment Practices Act, it was not uncommon for people to encounter blatant forms of racism and discrimination, either as job applicants or employees in their workplace. 50 years ago, racism in the workplace was largely condoned, sadly enough. Today, we can take pride that we've come a long way in improving protections for California's workforce. However, our work is not finished. Racism and other forms of discrimination are not as overt as they once were, but ever present, unfortunately, in the employment context, often in different, more subtle forms that were not necessarily anticipated back when the Fair Employment Practices Act was first enacted. An important part of our job as policymakers is to evaluate and assess the effectiveness of the laws we enact so that we may ensure that they are having their intended effect. That is the challenge we face today, determining how effective our current statutory and enforcement schemes are in responding to new forms of discrimination. This task is particularly daunting in light of our current economic crisis and our high unemployment rates. We're thankful to our speakers who are here with us this afternoon to assist us in this endeavor and look forward to hearing from all of the interested stakeholders. We will have three panels today. During the hearing, from our first panel, we will hear Professor Joseph Blasi and Dr. Joseph Doherty from the UCLA Law Rand Center for Law and Public Policy, who have taken the very ambitious evaluation of the Fair Employment and Housing Act as it's currently enforced. Thank you for that. They will be presenting their key findings and recommendations, which were recently released in an extensive and extremely informative report. The second panel will be comprised of representatives from the Department of Fair Employment and Housing, the Fair Employment and Housing Commission, and the State Consumer Services Agency, who will present their responses and ways in which we can improve our current enforcement. And finally, we will have a panel comprised of employee and employer advocates who will provide us with their own perspectives. For each panel, we ask that members hold their questions until all the witnesses in the panel have finished testifying. And after the panels have concluded and we have our opportunity to hear from committee members, we will then, of course, have an opportunity to hear from the public in public testimony. I know Chair of the Assembly Judiciary Committee, Assemblymember Mike Feuer, should be joining us in a little while, and he had some remarks to make, but hopefully he'll have an opportunity to do that a little bit later. But I would just like to ask other members of the committee, the Assembly Committee who are here, if they have any comments they would like to make.
Thank you, Madam Chair. Very briefly, my name's Van Tran. I'm the Vice Chair of the Assembly Judiciary Committee. I'm very happy to be here with my colleagues to, of course, have an oversight hearing on a very important issue that covers the activities and, of course, the work of the state of California. There are a lot of witnesses this afternoon that we're going to hear with a lot of issues, important issues that will affect, of course, our work as well, and I'm very happy to be here this afternoon to take in the information. Obviously, our job as legislators is to deliberate on many of the information and documents and data that we have, and then take that from there in terms of legislation, if necessary. Obviously, this is an area which has been around for about 15 years in terms of the agency, but also in the practice of law as well, in which I've been involved in my previous life, and it is something that I'm very interested in as well. So once again, thank you for the opportunity, and I'm being very brief because there's a lot of witnesses in the panels this afternoon. Thank you.
Any other comments from the members? Thank you very much for being here, incidentally. All right, so our first panel which is FEHA at 50, findings and recommendations. We have about 30 minutes set aside for this panel. And I'm sorry, I believe Professor Blasey, I mispronounced your name earlier. My apologies. So we have Professor Gary Blasey, the UCLA School of Law, and Dr. Joseph Doherty, Director of the UCLA RAND Center for Law and Public Policy. Whenever you're ready, gentlemen.
Thank you, Dr. Doherty. We'll begin. Thank you very much for having us here today. I'd like to thank the chairwoman for chairing this and for calling this committee meeting. I'd like to thank the members of the committee for listening to us academics talk about what we think we know best, but may not. My name is Joseph Doherty. I am the director of the UCLA RAND Center for Law and Public Policy. I also run the empirical research group at the UCLA School of Law, and I teach empirical legal studies to law students at UCLA. My colleague Gary Blasey is my co-author on this report. He's a professor of law at UCLA for the last 20-something years, and he teaches evidence gathering, among other courses. I'd like to begin by apologizing for the printed report that you have. We wanted to get our report out as soon as possible, and in the process of typesetting, a number of grammatical and typographical errors were not caught. We're in the process of correcting those, so thank you for your indulgence. I'd like to begin with the purposes of our study. The idea for the study came from Director Cheng, who nearly 2 years ago approached us with the idea of examining their rather large data set of complaints to try to determine what the agency has done within the time period in which they have those data. That's mostly 1997 through 2008. We extended our study beyond her original request to try to expand it to look at the entire system of enforcement as it evolved over the last 50 years. We're looking at both the effectiveness of the law and the efficiency of it, looking at the costs and benefits of this system. We're not particularly interested in individual effects. We're really interested in the system as a whole. We're looking at the effectiveness in terms of how FEHA works on its own terms to deter, compensate, and correct discrimination, but also the relevance of the original goals of FEHA in light of our current understanding of how discrimination operates. We're looking at efficiency, especially in terms of the deadweight costs imposed on employers who do not discriminate. Our focus is systemic, not individual. We recognize that our data ends before 2009, so it is not the current data. It also, most of this study is in the time period before Director Cheng became the director of the department. And we recognize that they've imposed significant changes to the system since then. These are the resources that we've expended in this study. Roughly 40 people at various levels contributed to it, about 8,600 hours. We're unaware of any study on this topic that has examined such large data sets and many different kinds of data. To put this in perspective, if we were to apply for a grant to do this study, it would be about $1.5 to $2 million. And we did it for the amounts here and for the in-kind contributions of the university and RAND. Neither of us came to this as experts or insiders in the field of employment law. One of us has written a bit about the implications of recent science for employment discrimination law, but neither of us has testified as experts in these cases. But we both have significant experience in analogous evaluation types of studies, and I've listed a few of them here. Whether our position coming to this study as outsiders has any advantage to the type of study, we'll leave that for you to decide. I want to say something about our association with RAND. Through RAND, we were able to get outside reviewers to study this, so this is a peer-reviewed study, both for the methodology and for the conclusions that we've arrived at. Now, these are our primary sources of information. Again, we cannot find any study anywhere of this employment discrimination topic that has covered such a broad range of data. So this is the most comprehensive study, even of the EEOC. There's certainly no federal study of this size, and there certainly are no state studies of this size. And then finally, I want to present to you some of the data that we're using in this, and I want to tell you or present to you the variables that we use in our statistical analysis, because one of the benefits of working with such a large data set is that we're allowed to control for many variables that may have a significant influence on the subjects that we're studying. We're using a statistical technique called logistic regression. We're able to control for the effects of many factors in order to isolate the effect of a single factor. So to give you an example, if we were looking at the difference between males and female complainants, we can control for the bases of the complaint, such as sex discrimination, race discrimination, disability, or age. And so what's left from that is the effect of being female. We're controlling for those other factors. And we think this is important for the conclusions that we come to and from the recommendations that we've made. So when we present our data, please keep in mind that we're controlling for those other factors. And now I'd like to ask my colleague, Gary Blasey, to walk you through our findings.
Let me add my thanks again for the opportunity to present our findings. On the slide is a not too artistic graphic, since I did it myself, but we haven't improved it. Basically, it's a representation that's commonly used in studies of dispute resolution systems. These systems generally begin with something that might become a complaint, then that complaint becomes a complaint, and then it's processed through a dispute resolution system. In California, we have 3 dispute systems. We have the EOC, which handles about 25% of complaints, and the state system, which is divided basically into 2 equally sized pyramids on the right, the DFEH and FEHC administrative system, and then the legal system. The pyramid declines to a point at the top because after all the processes have gone through, each of these systems produces a final ultimate result if the case is not resolved before that. In the case of the civil litigation, it's a jury verdict. In the case of the administrative system, it's a hearing before the FEHC and a decision. So it's important to understand that we're attempting to look at this entire system. We're not going to focus today on the EEOC, but we do include in our report some information about that. I should also point out that there's a little bridge there, and not very artistic again, indicating that about 8 or 9% of the complainants move from the administrative system to the litigation system, or at least potentially the litigation system at some point after they file their complaint. Looking at the composition of complaints, obviously there are complaints that are not warranted and shouldn't be found meritorious. There are instances of discrimination that don't lead to a complaint. Social scientists look at what are called complaint rates. It's often thought that California is an outlier in this respect. We didn't find that, actually. We looked at complaint rates in other states for which data was available, and we looked at in this slide, the administrative process in particular, because these other states do not require that cases go through the administrative process before they go to litigation. So comparing apples to apples, as the phrase goes, this compares the complaint rates in California to other states. We find that California is roughly in the middle of some of the large states in terms of complaint rates. Overall, the complaint rate's about 1 complaint per 1,000 employees per year. So our 18,000 employees, about 16,000 of whom are employed at this point, unfortunately, generate about 18,000 complaints on average. That will vary. Over the course of the 11 years of our study, we found significant changes in the complaints being filed. I'm not going to get in at this point to the explanations for this, but just descriptively, what we found is that complaints for sex discrimination, for race discrimination, national origin, and color discrimination declined fairly significantly. Age discrimination maintained at about the same rate, and the number of disability or medical condition complaints rose fairly dramatically. I should point out that there are a couple of upticks here in 2000 to 2002, and again beginning in 2007. We think that those are related to changes in the economy throughout all kinds of employment discrimination systems, the EOC and certainly California. There's a larger number of complaints when there's more unemployment, more terminations, and so on for reasons that we could go into, but don't have time to now. In terms of the composition of complaints, this has also remained fairly constant, and as you can see, terminations, complaints for discriminatory terminations lead the list, not necessarily because this is the most common act that involves discrimination, but perhaps because employees who are still employed have significant incentives not to complain, and those who have been terminated both may have feel the freedom to complain about legitimate discrimination, and then may also feel some ulterior motivation resulting from an unhappy termination. Harassment is the second largest, and working conditions together. Those three account for about 3/4 of the acts that are alleged. Each complaint can allege up to 4 acts. Most only allege 1 or 2. I would only point out in relation to this that this doesn't necessarily reflect the distribution of actual discrimination in the system. So, for example, you'll see that failure to hire cases only really account for about 3% of the complaints. That's not because the labor markets are free from discrimination, but because people who are not hired often have no way of knowing the reason they were not hired. That's why in the housing system we have a testing program to find out what the reason is. But that's probably the main explanation for the relatively low rate of those. One of the major findings, I think, of our study is that there is a significant disparity in which of those pyramids different categories of people have access to. These are some of the categories, and these are the odds that a person in this category, controlling for all of those other factors that Dr. Doherty mentioned, will have to obtain a lawyer and thus enter the civil litigation side. So controlling for all those factors, African Americans have a little less than half the odds of whites. You'll see all the other non-white groups also have significantly lower levels compared to whites. And by the way, this does not mean that these cases involve race discrimination. Remember that we control for that. So some of this is contributed by disparate availability of lawyers in disability discrimination cases or age discrimination cases and so on. Some of the most striking differences are in basically the level of employee, and as I'll explain in a minute, really the wage rates of folks. So construction workers, wholesale trade workers, which would include warehouse workers, have about 1/6 the chance of government employees of obtaining a lawyer, controlling for all those other factors. This is what logistic regression allows us to do, and with 250,000 cases, we can isolate the effects of these particular things. The full tables of all the various factors that contribute to the odds of obtaining a lawyer, which is really the gateway to getting into the civil litigation system. We found no evidence that there's any significant amount of pro se litigation in this area. The reason for that disparity is really one of economics, and the economics of the contingent fee practice, which is the practice that we have on the civil litigation side. Lawyers make decisions based on what they expect the value of a case to be. We found through our interviews and surveys that There are very few lawyers who are willing to take a case that they believe is worth less than $50,000. That's because when you compute the odds of their winning, their fee rate, the amount of time that it consumes, and so on, they believe that that they should not take a case that involves less than that amount. That's a bit troubling because the median annual wage in California as of 2008 was $36,000 and a little bit. And there are large numbers of employees, obviously, who earn substantially less than that. Those numbers are on the board. This effect may account for some of those other changes, but we've attempted to, or for those other disparities, we've attempted within the data that we have to control for those. So the consequence of this is also possible to compare how the legal system responds and how DFEH responds. So in this chart, we compare people's odds of obtaining a lawyer and getting into the civil litigation side and their odds of being accepted by DFEH for investigation or obtaining a remedy at DFEH. And what we find is that basically the administrative side is basically a mirror image of the legal side, the civil litigation side, whereas African Americans have half the chance of being accepted by lawyers. Their cases are accepted 33% more likely at DFEH, and you see the same rough sort of mirror image here. That acceptance is just the acceptance for investigation. If you look at whether someone gets a remedy or not, then you see, comparing some of these occupational categories, the odds of a construction worker, retail trade person, warehouse worker are quite low at getting into the civil litigation side. If they go to DFEH, their odds are comparatively better. Another important thing about this slide is it suggests that these decisions made by lawyers are not just about case quality. They're not based on an assessment of merits. They're really based on the expected value of the case. And of course that has something to do with merits, but it seems primarily driven by the expected damages, and that again is primarily driven by wage rates, lost wages being the main component of damages in these cases. If we look at, did I miss this? Whoops.
No, you're with the processing.
Okay. Okay. So this is the actual pyramid on the DFEH side. So I'm going to spend a little bit of time on this. So 100% of the cases come in the bottom. 20% of the cases are rejected for investigation. I should say that about half of all the cases that show up at an intake interview are rejected by DFEH and don't even enter this. So we would have a much larger bar here at the bottom, except that they don't really collect any information about those cases, so we couldn't really analyze them. The process continues. Again, about 9% of the cases leave to get a right to sue letter, either because they've got a lawyer or for some other reason. And the main drop-off is a determination that the case lacked probable cause. As you'll see, most cases are found, if they get to that stage, to lack probable cause. About 13–14% of them survive to that period. And if they survive to that period, of the remaining, about 1% of them are sent forward to the legal division for processing for an accusation, and the remainder are settled. Some of these changes, some of these numbers may be changing under the current system. We don't know whether that's the case. I think Director Cheng will talk to you about the case grading system. One thing I would point out about this is that the no probable cause finding in recent years, in the last 3 years, it's taken an average or a median of 345 days to get to that finding, during which time there are significant transaction costs incurred by both the DFEH and the employee, but especially for the employer. So those are some of the cases that probably should be thought of in terms of deadweight transaction costs, especially to employers. In terms of the results of this system, These data are actually for a little more recent time period. That's why it's a 14% instead of 12%. About 14% are settled with or closed with a closing code that indicates that they were settled. In about half of those, we find some monetary benefit recorded in the data. Over the entire period, that was $3,000. Over the more recent years, it's closer to $4,000. And in some of the other cases, there are non-monetary benefits. The most common non-monetary benefits are the dissemination of information or the posting of a DFEH poster. As I say, 1% then of the cases that begin with DFEH are sent to the legal division. Before I get to that point, let me stop and go back to talk about the cost to employers of this process. So based on our interviews and surveys, it appears that employers incur costs, if they hire lawyers, of about $5,000 to respond to a DFEH complaint. And that can go up to about $15,000 if it stays in that system long enough to go to the commission. Now, larger employers tend to handle these matters in-house, and so we don't have a good way of knowing what those costs actually are. But for smaller employers, the use of lawyers is fairly common, and these are significant costs, although, as you can see, they are significantly lower than the costs on the litigation side. And these, I should say, are probably lower estimates. At least they would be low in the Los Angeles defense bar market, the bottom three numbers. Going back to that 1% of cases who are sent to the legal division, it's important to understand the legal division has 16 attorney positions. We consider about 9 of those available to handle employment matters because 45% of the accusations filed by the legal division are housing cases. They're much more likely to file a housing accusation than an employment accusation. About 2/3 of the requests lead to an accusation. But both the request for an accusation and the issuance of accusations has declined dramatically over this period. Really by about 1/3 over the decade. We began the decade with about 150 accusations a year. We ended in the last 5 years with 51 accusations a year. Overall, in the more recent period, about 3/4 of the cases settle. And in the legal division, the settlements are higher, between $15,000 and $20,000. And about 6% of those accusations go forward to the Fair Employment and Housing Commission. The commission is authorized to have 7 commissioners. It currently has 5 commissioners. It takes evidence and gets recommended decisions from administrative law judges. There are now 3 administrative law judges. Last year, when we were preparing the study, there was 1 administrative law judge in a state with 18 million employees. We're happy to know that she has some help this year. The commission has several functions, the major ones being to issue regulations that interpret the Fair Employment and Housing Act in various ways. Those interpretations are accorded great weight by the courts, and so they're important. It also adjudicates those accusations brought by DFEH. And again, those adjudications and the resulting decisions have fallen dramatically. The commission issued over an 8-year period about 5 per year. Last year it issued 3 decisions. When it does issue decisions, DFEH tends to prevail, and in commission decisions, the median monetary award's a little short of $40,000. Quickly moving on to the civil litigation side, not everyone who gets a right to sue letter files a lawsuit. About half do, a little less than half. Those who don't file a lawsuit might settle their case before they get to the point of the needing to file the lawsuit, or the case may fall apart and be rejected by the lawyer. We don't actually know what happens to the ones who don't go to court. As with all other civil litigation, the great majority of these cases are settled. We don't really know the distribution of outcomes because that information is extremely hard to get in any reliable and systematic way. But we can really only look at what happens at the end of that process, which we did. About 100 cases per year currently will be tried to a jury verdict. Those are split almost exactly evenly between plaintiffs and defendants, which is what legal theorists would tell you should happen, so it does happen. There are some very striking findings in the more recent data. In the 2-year period, there were 22 trials in the state tried to verdict on sexual harassment, and the plaintiffs, all of whom were female, lost 21 out of 22 of those cases. I looked recently at the more recent data, and it's not quite so one-sided, but it's still significantly less than 50%. The median jury award currently is about $205,000. That would not include attorney's fees where those are granted. And the amount of the award varies significantly by the nature of the claim. So disability claims tend to lead to an award close to $250,000. Race discrimination claims, about 20 or 30% of that.
I just wanted to let you know we have about a 5-minute warning. Thank you.
Let me... 40,000 and then jury verdicts that average $205,000, and then settlements, we don't know how high those are, but they're certainly, I would think, quite higher than be closer to the 200,000 than the 4,000. We think partly this is probably the result of resource disparities. On the one pyramid is essentially staffed by more than 1,000 plaintiffs' lawyers. The administrative side is staffed by 9 lawyers, or 9 lawyer equivalents, and 74 consultants. The requirements to be a consultant are that you have a high school degree and 4 years in state service. You need not necessarily have any training that's relevant to this area. All the training is now currently provided on the job. There is on-the-job training, but previous cutbacks have eliminated a training academy. So there's a rather uneven quality in the consultants. And in any case, this is a very complicated law to work with for anyone who's not very well trained. There's also a structural difference, which is that when in the litigation side, when people settle cases, they settle them in what's called the shadow of the ultimate potential result, which is a jury verdict above $200,000. On the administrative side, they're settling them in the shadow of less than $40,000, and then that's only in about 5 cases a year. And then finally, there are also this possible structural thing of the lawyers filtering out higher value cases. To some extent, that probably does reflect a little bit on the merits of the case, but again, we think that looking at this data, primarily driven just by the level of the wages of the folks at issue. These disparities, we think, don't matter just to individuals. Obviously, they might matter to individuals, but looking at this as a system, if we look at the system that's provided by the administrative process, it appears that we're not providing much in the way of deterrence, and that was one of the goals of the FEHA, to industries that are primarily staffed by lower wage workers. We're not offering much protection to people in lower wage occupations. And there's a significant regional effect. Los Angeles and the Bay Area will not be a surprise, have plenty of lawyers. The Central Valley has very few lawyers, and I'm sure many people in the Central Valley like it that way. But in terms of access to someone, if you want a lawyer to handle an employment discrimination case, in Bakersfield you won't find a single member of the Principal Association of Plaintiffs' Lawyers in a fairly significantly sized town. So our general conclusion is that over time we have evolved 2 systems, and these produce substantial disparities in access, in outcomes, and in deterrence, that this is primarily the result of legal market effects of the contingent fee system, inadequate resources for the administrative system, and some of these structural differences. We also wonder, looking at the science, that whether we should have a system that's so reliant on the sort of intentional tort model and deterrence. So our general recommendations, we have detailed recommendations in the report, are that in order to at least somewhat equalize these 2 systems, we need to improve the administrative DFEH and FEHC system. We make some recommendations in how DFEH could become more effective in using the resources and information that it has. But it's also relatively clear that the amount of resources provided to one system versus the other are quite different. Not to say that processing complaints is the only way to go. One of the things we heard over and over from both sides, from the employee side, the employer side, and from neutrals, is that smaller firms in particular aren't able to afford a human relations function or human resources function. And so they really lack the training they need to avoid discrimination that they would prefer to avoid. DFEH does a significant amount of that, but that's an area that could significantly be improved. And then finally, as we say, we recommend that the state take a hard look at the basic underlying premises of a law that was adopted 50 years ago, given what we now know about how discrimination operates. Thank you.
Thank you very much for that presentation. It's certainly enlightening and eyebrow-raising with regard to the disparities that you have explained. And let me first open it up to any questions members of the committee may have of this panel, and I may have a few. Any questions, members? Assemblymember Fuhrer?
Thank you. Thank you. Thanks for the presentation. If there was one thing that you thought was the most important step the legislature should take right now, given the limitations of resources and other factors you've discussed, what would it be?
I would go to the word resources. Where this is beyond our expertise, I would consider removing this is an agency that depends on the general fund, and have it funded by a small fee paid by both employees and employers, who are both the beneficiaries of a system, so that we would have a system that's both more effective but also more efficient for employers, so that, for example, employers who have a complaint against them that's not valid will have that invalidity determined much more quickly. I leave to you all whether that's feasible or not, but I don't see how any system that's operating at the level of 81 cents per employee per year can really achieve the kind of results that are anywhere close to comparable. And I would not use all those resources for the deterrence side. I would use a significant number of those for the education side and working especially with smaller employers. I don't know the California data, but nationally, close to a third of the employers are of a size where they're not likely to have a human resources capacity.
And so given the economy and given the stresses that both employers and employees are confronting, just to work out some math, so if it was 81 cents per employee per year from the general fund under current circumstances, if it were a nickel per month for each of an employer and an employee, that's $1.20 annually. It increases the resources by 50%. Do I get the math properly?
You're better at math than I am, but that seems about right.
Okay, thank you.
My question would be, obviously we understand the resources issue, and you've come up with a potential solution that we can discuss further, and I'm sure we will in the following panels. But in addition to just additional resources, additional funding, in your study, did you come up with any other suggestions that may be structural, that are not necessarily so revenue-driven? Any other suggestions beyond just additional funding for them?
Well, one of the things we suggest is that the Department Legal Division should not be completely restricted to pursuing cases through the FEHC. Because the FEHC currently is really not capable of providing that sort of adjudicatory function that will inform the process that goes back to all those other settlements. And if the department were able to go directly into court, especially limited jurisdiction court, where the costs are not likely to be much higher than they are in the administrative system, we think that might equalize things. And we're only talking at the current rate of about 90 cases a year statewide. So that would be one possibility.
And do you think that the numbers of complainants are affected in any way based on the outcomes? In one of your earlier charts, you showed that there are other states that receive a higher percentage of complaints. But I'm just wondering if you have any thoughts on whether people are not, becoming part of the system to address these issues because of the results that are received.
Well, we have heard anecdotally, we don't have any empirical way of verifying this, but that some people don't have confidence that their complaint will receive adequate attention unless they have a lawyer, and so when the legal market shuts them out, they feel shut out completely. I should also say that to the extent that it's the expectation of great reward that brings people into the civil litigation system, contrary to popular belief, California's average awards in these areas are actually significantly under the national average. In all cases, they're about 20 to 30% under the national average in each category of discrimination awards. But the primary difference, I think, in terms of people who may not be complaining at equal rates probably has more to do with their either willingness just to accept the situation or their lack of adequate trust in the administrative system.
And then my last question, which I think is very interesting and intriguing, the issue that you brought up, that education that could hopefully help people not enter into these situations where people are harmed, hurt, discriminated against, is a very important part of the process.
Absolutely.
So additional resources towards education, do you have any thoughts on how that would impact the system, maybe make this an interesting possibility for small small business to be interested in entering into, because perhaps it's a cost-saving issue? Do you have any thoughts on that, how that impacts the overall cost to small employers?
Because the number of complaints is relatively low, and because people can acquire employer practices liability insurance, the premiums of which are somewhat driven by people's experience rates, I think for most small employers, the odds of them receiving a complaint at any one time are fairly low, and so they don't really take precautions. But it's probably the case that a significant number of complaints would never arise in the first place because they arise because of lack of knowledge as opposed to some particular animus on the part of someone. Not to say that the animus doesn't still exist, but we know, especially in the area of disability discrimination law, which is very complicated, smaller employers really can't, without a lawyer or a professional guiding them, have any serious understanding of anything beyond things like wheelchair access.
But a small fee may be cost-effective.
I would think that it certainly could be if it were well designed and carried out.
Mm-hmm. Thank you very much. Question from Assemblymember Monning.
Thank you, Madam Chair, and co-chairs for convening this. Thank you for the presentations that you've shared. I'm wondering if you have data that shows trends. You illustrated private bar taking these cases generally when there's an expectation of an award of $50,000 or higher. There's a category that fall below that. Do you have any data on trends of the availability of private attorneys who will take those cases under that threshold, and has that affected a decline in people receiving a right to sue letter but not pursuing any further remedy after they get the right to sue letter?
We don't have enough data to map trends in the conversion rate from right to sue letters to lawsuits, because the best we could do was take a sample of right to sue letters and then see what happened in court. And that was an extremely time-consuming thing to track down 400 cases that might or might not have existed all over the state. So we don't have the data to know about that. I would think that since the legal market is also experiencing some difficulties, there would be some lawyers who would be willing to accept cases of somewhat lesser value. On the other hand, there's not any particular indication that juries are finding any differently in these cases. In fact, usually in economic downturns, juries may be more sympathetic to employees. So it's very hard to say, and I guess the short answer is, as an empirical matter, we just don't know.
Would it be fair to say the employee who has damages that may be estimated as less than $50,000 does have a harder time finding counsel to represent them, and that the strain on DFEH resources, some of those decisions are economically driven as opposed to merit-driven in terms of decisions?
Well, there's just no doubt about that. I mean, all the evidence points in the direction of it not being merits but economics that's driving whether you get into one system or the other. I mean, that said, DFH will tell you that they do process all complaints. They do reject half of them at the outset, and they reject a lot of them along the way. So merits do play a role. Whether if they had more lawyers and more resources, those numbers would be quite the same, that's an open question. One of the things that DFH has had to do is to change how it does business. So now all interviews are conducted on the telephone. And most lawyers would tell you that if you had your druthers, you'd like to see your client face-to-face and be able to judge their veracity and so on, for the same reasons we don't do jury trials by telephone. So the sort of level of advocacy potential, I think, is reduced because of resources. And I suspect that someone could, and actually there are a handful of lawyers who handle what I would call the sort of equivalent of the whiplash case, a very small case. And they rely almost entirely on DFH to do all the work, and then they slip in to try to get some attorney's fees out of it at the end. A very small number of those people, from everything that we could tell, talking to employers and employee side folks.
Thank you. In the interest of time, I know we'll have other testimony. I imagine some of that availability is rooted in demographics as well, a small rural area versus a urban center.
Absolutely. And so in the rural areas, DFH handles a much higher percentage of these cases. I think in Bakersfield, I think the right to sue letter average is like 20% as opposed to 60% in Los Angeles.
Thank you.
Thank you.
Thank you.
Thank you. We have one last question from Assemblymember Hagman.
Thank you, Madam Chair, and thank you guys for your report here. I do have a couple questions about your graphs. First of all, the ranking one where you have California number 4, is it number 4 out of the 50 states, or you just put some states up there? How do we rate? We're the top half, the bottom half, that sort of thing.
I'll take that because it was my job to assign a research assistant to call all 50 states. It was all the data we could find. Smaller states typically don't report this, but the larger states tend to have an annual report. We pulled it all out.
So these 7 states are the only ones that really reported at this point?
Actually, I think all the states that we found are in the report. The graph doesn't account for all of them. There's one that we didn't include was Pennsylvania, but it's different because Pennsylvania also captures what would be the right to sue letters in California, so it's not really a comparable state.
Okay, and then trying to extrapolate a little more out of this, California is about half what Ohio rate is, and you looked at their system versus our system of labor laws and access. You have a correlation between that. Or diversity in Texas was about half, third of ours.
No, it was a lot of work to figure out California's system, so we'll rely on colleagues in Texas and Ohio to do that.
Okay, and except for the economic downturns back in 2001 and currently, it looks like the number of complaints have been going down. Do you think we're doing a better job as employers in this, or just less being reported?
Well, the number of complaints is actually fairly stable, and it is responsive to economic conditions. The composition of all the complaints, we only listed the most common kinds of complaints in that graph. I think now DFH will probably tell you they're getting more complaints, I would guess, than they have gotten any time recently, primarily because of the economy.
So when the employers lay people off, for example, they try to find a reason, maybe not just economically, but the reason why you selected that person versus somebody else. But before, in 2006, I'm looking at each category. One started at over 8,000 per year, and then we're down to under 6. I mean, so significant declines for that trend.
I think for race discrimination, sex discrimination, I think there's probably a mix of stories. One of them certainly could be that there's less discrimination out there. I mean, certainly the overall trend over time is less discrimination or a changing type of discrimination.
Thank you, Chair.
Okay, thank you very much, gentlemen.
Thank you.
We're now turning to our next panel, for which we have 30 minutes allocated for 6 participants. So we're going to want to move this along at a good clip. We will hear from the Department of Fair Employment and Housing, its Director Phyllis Chang, Tim Muscat as Chief Counsel, Anne Marie Bellotti, who's its Associate Chief Deputy Counsel. Actually, we have, and then we have the Fair Employment and Housing Commission, Patty Perez, the Commissioner, and Ann Noel, Executive and Legal Affairs Secretary, and the State and Consumer Services Agency, its Deputy Secretary for Legislation, Laura Zuniga. Director Chang, welcome.
Thank you very much for having me. It will just take me 1 second to set up the PowerPoint.
as you're setting that up, I think everybody here is very grateful for your hard work in trying to make the best of a very demanding and challenging situation when you came to the agency.
Thank you very much. I really love my job. I can't think of a more meaningful job, and particularly at a time like this. I'm not able to get this on, unfortunately. Yeah, it's
What?
not.
I'm sorry.
Pardon me.
It's only working on this little thing right now.
If this is the apples and oranges presentation, each of us has our own fruit basket that's been assigned to us here. So we actually do have the materials here if you can't find it on the computer.
No, because he disabled this. I'm sorry.
Well, how do I?
You go to my computer. This technical assistance isn't costing anybody.
Yeah, it's also worth what she's paying for it.
I can't believe only this thing is working.
It doesn't suit your drive either.
And truly, Ms. Chang, if it's not easy to find, we do have the material in front of us.
Try the lower one.
1 second. Let's see. All right. Where is it? I should have used my own computer.
There you go. There you go.
Okay. Can he enable the?
Well, he's not around.
Ms. Chang, I am going to encourage you, I think, to rely on the
All right.
paper.
Okay.
We all have it, so it's not really a great loss.
All right. Well, thank you, Chairperson Corbett, Chairperson Fewer, senators, assembly members, committee staff, and distinguished guests for inviting us here today. Let me just introduce our panel. Tim Musket is Chief Counsel of the Department of Fair Employment and Housing. Anne-Marie Bellotti is the Associate Chief Deputy and Special Projects Counsel. We also have colleagues from the Fair Employment and Housing Commission, Patty Perez, Vice Chair of the Commission, and also Chair of the Labor Employment Law Section of the State Bar. Ann Noel, the Legal and Executive Affairs Secretary, and Laura Zuniga, Deputy Secretary of State and Consumer Services Agency in Legislation. Now, I'm glad that you have the apples and oranges PowerPoint in front of you. As Professor Blasey and Dr. Doherty said in early 2008, I invited this study, and the purpose was to study the progress of the law, the gaps there might be, and where the law should be headed for the next 50 years. And we thank the UCLA RAND Group for doing a wonderful job and very dedicated, very difficult work. We received 15 questions from the committee staff, and I grouped them into 5 categories. And they are, does the system work? Are different outcomes meaningful? Are current resources enough? Can the system be improved? And finally, what are the priorities going forward? Going to the next slide, perspective, let me underscore that there are 2 different perspectives here. First, the UCLA RAND study is primarily retrospective. It goes back to the last dozen years or so, prior to the time I was in this position. Secondly, that study underscores a theme of separate and unequal in our legal system. On the other hand, the department's perspective is prospective from this time going forward, and also our theme is that the differences between the civil litigation system and the administrative system is primarily different but complementary. So, going to our first question, does the system work? We received a long question that basically states that a well-designed regulatory system should accomplish its goals of compensation, correction, and prevention effectively. So I'm going to address each of these subparts of the question. As to compensation, going to the next chart with a little pie chart. This is a pie chart of the fiscal year 2008-2009 settlements for the Department of Fair Employment and Housing. Now, we receive about 20,000 complaints a year. About 18,000 of these have to do with employment discrimination. And Professor Blasey had described what happens in the process, but this is ultimately what happens in outcomes. My department was able to settle 909 cases, or just over $9 million worth of cases. The vast majority of these cases were settled pre-accusation, which means before we took any legal action by our investigators, before many times any merit finding was found. They settled $6.4 million worth of cases. The average amount was $7,629. Now, for the cases that are post-accusation, when we issue an accusation that goes to legal, the legal division settled almost $2.6 million worth of cases, 63 cases, and the average amount was $40,000. Now, there may be a little bit of difference in these numbers because the UCLA RANCITY use median, and we're using average. Now, although we only have 16 attorneys, each of these attorneys has about a 5-to-1 investigator to a lawyer ratio not seen in private firms. Private firms do not have full-time investigators. Also, in addition to the settlements, the dollar amounts, we also provided for affirmative relief as well. Now, for the settlements themselves for monetary reliefs, yes, sometimes there were very small amounts or even no monetary relief, say getting your job back or getting a place to live. That's actually worth a lot. However, some of our highest settlements rival the private bar. In 2009, our largest settlement was a $618,000 class action in a housing discrimination case in Orange County. The highest judgment for an employment sexual harassment case was, in fact, before the commission for $111,000 involving sexual harassment and retaliation of 2 farm workers. So these are significant numbers, and these are cases that we're keeping out of court. Going to the issue of correction, what are we doing to correct existing practices out there? Well, in terms of affirmative relief, these are the types of things that private counsel do not provide for in their settlement agreements. We require posting. We require education and training. We require updating policies and procedures to comply with the law, to provide notice of the violation and remedies to the employees of that employer, to provide a notice of completed training back to the department and to the commission, if it's before the commission, as well as proof of compliance. Although our mediation program is small, it's actually quite mighty. We have 2 full-time housing mediators that settle cases successfully at a rate of 66%. We have a cadre of volunteer mediators who settle cases successfully at a rate of 76%. And we are currently in the process of advertising for 2 full-time attorney mediators. Going to the page on prevention, what are we doing in terms of outreach and education to prevent incidences of discrimination? Well, we're doing a great deal. We have extensive statewide outreach. During the 50th anniversary year, the department went out and spoke and worked with community groups in about 200 instances. I myself, in 2009, gave over 80 speeches throughout the state to stakeholders, to attorney groups, to employers, and to employees. We also provided technical assistance and training wherever needed. For example, the department has 3 employer roundtable groups that we work with, and we've been working with these groups since the 1980s. The Southern California one in Los Angeles is extremely active and just had a huge conference with over 100 people attending. And the Central California Employment Roundtable, which is based in Fresno, also had a very large training back in March, and we are currently planning a Northern California Employment Roundtable training event. I provide case law alerts to over almost 4,000 individuals, attorneys, HR professionals, on every single California 9th Circuit U.S. Supreme Court decision as it comes down. I also write a column on cases pending before the California Supreme Court on labor and employment law through the state bar. The department has tried to maximize its resources by mass communications. We produce with our own staff as writers, directors, producers, and actors several videos to train and teach people about how to comply with the law. They're on our website with lesson plans, frequently asked questions, and resources. Working with the Department of Education, we sent a video of Equal Rights 101, which is all about employment discrimination, to every single California high school. And then followed up by that, we went out to 50 to 100 high schools in California, public high schools. We ourselves went, and we also recruited private counsel to come and talk about how to comply with the law, and it was extremely well received. It was so well received that we developed another set of training on Fair Housing 101, public accommodations, and hate crimes. All of these videos are not only on our website, but they're also on YouTube. We have information on Facebook so we can reach a younger generation. We also Twitter our case alert. So the next slide would have been, are different outcomes meaningful? There are essentially two different types of outcomes this committee has been looking at. The private bar fee versus DFEH, and the EEOC, the feds, versus the state government. Now, going to the next page, why do parties opt out? You will see that on the Apple side, we have private litigation, and on the Oranges side, you have the DFEH. And I've outlined the general reasons why people opt out of the administrative process. Well, looking at the apples, higher damages in individual outcomes with very little policy impact. That means if you earn a lot of money and you think that you can get private counsel and you have a chance of winning a jury verdict, you may want to opt out of the process. That's for employees. Why do employers want to opt out of the program? Well, they might want to opt out because they think that they can prevail in dismissing the case through summary judgment, which is a process that's still not before the commission at this time, and maybe it's worth it to do that. Otherwise, there's also the result of all of this is there's less diversity among the plaintiffs' class. However, that group also reflects the labor force of people who are earning more money. Looking at the Oranges side, well, when people stay in the administrative system, what do they get? They get greater affirmative relief and policy impact in all outcomes because we're trying to prevent future litigation. Lower wage earners get relief. And there's also greater diversity about among the complainants to reflect the pool of people who do not opt out. Yes?
Let me just interrupt for a second about time management.
Yes.
We have half an hour for this segment. We spent about 12 minutes so far, and there are 6 of you here. I'm trying to determine, are you speaking on behalf of the department?
I'm almost done. I'm almost done.
Okay, because are your colleagues going to be speaking also as part of the department's presentation?
Yes, very, very briefly.
That'll have to be briefly. Okay, go ahead.
Okay. Costs and benefits for litigants. Acceptance based on merit and monetary worth on the civil litigation side. Fee for services. Discounted damage awards. Limited affirmative relief. Unlimited discovery, protracted litigation. Unlimited damages. Unlimited risk and exposure, and no help for small cases. On the other side, on the administrative side, there's acceptance based on merit only, free services, nobody has to pay for attorney's fees or costs, filing fees, full damage awards, we don't take anything from the damage awards, routine affirmative relief, limited discovery, 90 days, unless otherwise stipulated for a case to be resolved, $150,000 cap on damages, fewer risks and exposure, and a safety net for small cases. And what are the costs and benefits for taxpayers, courts, and businesses? Well, in terms of private litigation, in a 1995 Administrative Offices of the Courts report, the estimate was that each judge day cost taxpayers $3,943. I imagine it's a lot more today. Also, having the private sector litigation leads to court dockets and expenditures of resources that'll be bloated. It also increases the cost of doing business. Now, staying in the administrative process at 81 cents per employee per year, it really speaks to the efficiency and effectiveness of the department as an alternative forum. It relieves court dockets and resources for thousands of cases and reduces the cost of doing business. And finally, let me just briefly talk about the difference between the EEOC and the DFEH. Yes, the EEOC cases tend to have higher outcomes. Why? Well, first of all, it has a narrower mission. It deals only with employment discrimination, whereas the department deals with a much broader mission. In addition to employment, we work on housing, public accommodations, and hate crimes. They file all cases in civil court. We file all cases before the commission, and many cases do opt out. 50% of our cases remain before the administrative body. 100% of the cases remain in court with the EEOC. The awards are not capped in the civil litigation through the EEOC. They are capped here. Are there enough resources? Well, we believe that we can yield greater resources through efficiency and effectiveness, as well as higher productivity. Going to the next page on greater efficiency and effectiveness, we've automated our appointment system. We've automated a right-to-sue system. We have telephone intakes, which allows us to cut down on space, and it's actually offered more often than before in terms of intake. We have a case grading system, which Tim Muscat will talk about later, as well as special investigations unit to ferret out systemic discrimination. We have proposed regulations to achieve greater transparency and savings in operations, all of which, some of which Anne-Marie Bellotti will discuss. Finally, I want to show you this chart on greater productivity, since we put in the case grading system. You will see that in 2007, which is the blue line, basically the number of open cases are fairly flat, fairly constant over a year. The pink one shows 2008. That's when we saw the beginning of the recessionary period and a huge growth of complaints filed with us. We lost positions, we cut back on funds, and you can see that the number of open cases grew. However, in the yellow line, you will see that that's when the year in which we put in the case grading system, and as a result, we are much more efficient and productive than before, and the number of open cases has been reduced almost by 2,000.
Thank you very much. I think we'll have to pause for a moment with you there, because it's almost half the time allotted for the entire panel. It's very important stuff, but we have a concise amount of time. So, Mr. Muscat, an exceptionally concise minute or so presentation, please.
Yes. I want to highlight the efficiencies that we've been employing at the department to try to move our cases faster and get greater outcomes. The first thing I want to talk about very briefly is we've adopted a special investigations unit. Our goal here is we want to move away from simply doing cases one worker at a time, but look to cases that we can start doing investigations that are focused on systemic discrimination to do class action work. We've been doing that with our SIU staff, which works under my direction. And the key that I want to point out in the slide I have on Government Code Section 12961, we don't need a change in law for DFEH to do this type of class work. We've always had the authority. The difference is we're now committed and focused on doing it. Generally, there are three differences in terms of how these investigations work. One, because they are very factually complex, we assign them to one of our SIU investigators who's trained on doing class-type investigations. Two, we assign an attorney immediately to these investigations. Again, they tend to rise a lot more legal issues, and so we think it's helpful to have that attorney-investigator teamwork. And three, we have 2 years to do these investigations. The reason why the extra time is important is because if we do make a determination that it looks like there's going to be a cause finding, we try to settle these cases like we do any other case. But in order to effectively settle it, we have to know the scope of all the employees that have been harmed. And so we spend a lot of our time interviewing the employees, identifying everyone who has a claim, and making sure we can make that claim in the settlement process. And then finally, in regard to the SIU, the results have been dramatic. We at DFEH have settled 3 class cases by ourselves in the last 3 months. It's the first time in a decade that DFEH has been able to do this. We've gotten over $712,000 for 59 workers as a result of these settlements. But more important than just these recoveries, we have gotten injunctive relief that's benefited over 10,000 workers. We're committed to doing this SIU work within our existing budget, and it's going to continue in the future. The second efficiency I just really want to mention briefly is our case grading system that Director Chang referred to. Basically, this isn't rocket science. We're telling our investigators to prioritize. We want them to be thinking about what are their priority cases, the ones that are going to lead to merit versus the standard cases. The attorneys meet with their assigned investigators on a monthly basis, and our goal is to move your cases faster. Get the priority cases to the legal division. For the standard cases, if it looks like there's not going to be any merit, let's close them and move on to the next case. And as Director Chang has demonstrated in our numbers, the results have been phenomenal. We are rapidly closing the number of per cases that our investigators have, and our results are still up there as they have been in previous years.
Thank you, Mr. Muscat. Ms. Bellotti.
In the interest of time, I'm going to just defer to my written statement, which is what I was going to say. So we do need your assistance with some legislative fixes, and I've explained that in some detail in the statement that I've submitted, and it's also covered in some of the slides. If you're interested in pursuing the legislation that the department is currently seeking, I have information that I can share with you if you want to email me or give me a call, 916-478-7247. We already have some draft language that's been prepared by the Office of Legislative Counsel that can be made available. Thank you.
Okay. Thank you. So now we turn to Ms. Perez, who is the Commissioner for the FEHC. Please.
Hi. Thank you. Thank you to all of you for allowing us to make this presentation. I have to say to begin with that even though I do public speaking for a living, I'm quite nervous, so bear with me.
Relax. Take a breath.
I'm good.
You have
I'm
10
sure I'm not the only
seconds, go.
person who's ever said that.
No, go ahead.
I think I'll start getting into it, and I'll speak fast, although I speak faster in Spanish, but I'll stick to English just to make it more understandable. I am here as the Vice Chair of the Commission, and thank you again for allowing us the opportunity to speak about what the Commission does and how we are involved in this process, which I am extremely proud to be a part of. I'm also here wearing a couple of other hats that I think are important to tell you about so that you can understand where my testimony comes from. The first is that I am, as former Commissioner, but current Director Chang mentioned, I am also the chair of a state labor and employment law, state bar labor and employment law section. I therefore represent, I'm certainly not here to speak on behalf of all of them, but I do represent a section that has over 6,500 members, largely made up of the private practice plaintiff and defense bar. So certainly that gives me a unique perspective in terms of this work. I also, in my private life, am the president and executive officer of an HR and employment law consulting firm in San Diego, where I do public speaking, where I'm not usually this nervous. Based in San Diego, but I do work nationwide, do primarily work in California, doing pre-litigation preventive work, no longer doing litigation. On behalf of the Commission, however, which is certainly the role that I'm here for today, I want to start out with just really the general statement that I think answers the big picture question of what the committee is concerned with today, and that is whether the administrative system is working. And on behalf of the Commission, I'm happy to report, and I'm proud to report, that it is working quite well. And despite the fact that these are certainly difficult times, the Commission is working alongside with our sister agency, the Department of Fair Employment and Housing, to balance our role to protect the civil rights of our citizens while at the same time certainly being fair to our employers. I'm going to focus on the three main areas. We do more than this, but the three main areas that the Commission works on, because it really is at the heart of the questions that you probably have today. The first is the area of adjudications. Since 2002, at least, the DFEH has issued between 75 and 100 accusations per year. Those numbers have fluctuated somewhat, but they've remained relatively steady. The one thing that has changed, and I think will continue to change, is although the numbers remain steady, the level of sophistication and the level of cutting-edge legal concepts that are being presented to the Commission from the Department really are at a much higher level, particularly because of the issues that have been discussed before, the case grading system and some other procedures. So we're excited to be able to work on issues that are really cutting edge. The opinions that are issued, the report does focus quite a bit on the fact that the number of opinions that we issue or the number of cases that would go to hearing before the Commission are quite low, and I want to address that from the Commission's perspective. Number one, I think, is the low number of hearings that we have. Again, keep in mind the number of accusations that are issued remain the same. I believe that the low number is really a testament to how efficient we've gotten and how good we've gotten at settling these cases before hearing. I'll note, as Professor Blasey mentioned, last year we were without a couple of administrative law judges who would normally hear these cases and perform the settlements and the mediations. Three of us as commissioners, myself included, stepped in and actually took over several of the cases, and I'm happy to report that we were actually successfully able to settle every single case that we as commissioners took on during settlement conferences. So it really is a testament to the fact that these cases are being settled prior to hearing, because that's the best way that we should be resolving these. And I also note that the number of hearings that we have in comparison to the accusations that we receive are actually higher in terms of proportion than the number of cases that are filed in the court system and that ultimately go to trial. So when you compare that, I think that it gives you a better idea. Another thing that's important, and Phyllis stole my line, but I refer to our small number of opinions and hearings that we have as small but mighty. In addition to the fact that we provide monetary relief, they are very far-reaching in terms of things beyond the monetary damages. They involve very cutting-edge issues, and in many instances, because of that, are actually designated to be precedential decisions, which are then citable by courts and by counsel. And in fact, several of our cases are eventually defended on appeal and become published cases, and that was true this year. I want to really quickly run you through a case study of a case that came before the Commission called DFEH. The real party in interest was Marina Chavez versus Acosta Tacos. This was a case involving Marina Chavez, who was a monolingual Spanish-speaking immigrant with a fourth-grade education. She was working at a low-wage job as a cashier at some family-owned taco shops in Los Angeles, really the prototype of the low-wage earner who probably would not have on her own been able to go out and get counsel for many of the reasons that had been stated earlier. She was pregnant. She gave birth 1 month early, but returned to work exactly 1 month after giving birth. Wanted to come back to work, needed to work. She was breastfeeding the child, and the father of the child brought the baby to the workplace so that she could breastfeed the baby off premises during her break. The employer found out about it, told her that he was not happy with her doing this and that he didn't want her to return to work until she was done breastfeeding. She indicated that she couldn't wait that long. She needed to work. She needed the job, needed the money. He didn't like that, didn't like her attitude in terms of the response, and fired her. That was a case that came before us last year that the DFEH brought before the Commission. We found, probably not surprisingly, that that was wrong. Specifically, though, and this is really a great example of cutting-edge issues, we found for the first time ever, no other case in the country has ever found this, that because breastfeeding is an intrinsic characteristic of females, that this constituted discrimination based on sex. So not only did we provide this low-wage worker who would otherwise not have been able to find relief, we ended up awarding approximately $46,000 in damages. More importantly, the affirmative relief that we've discussed earlier was implemented in this case. Policies and procedures in English and Spanish are now being implemented, and other affirmative relief is going to help not only Ms. Chavez but others. Maybe more importantly, however, this case is now one that has been cited because we did make it precedential given the unique legal issue that came up. But in addition to that, and this is really thanks and kudos to the department, as a result of wonderful PR, this case ended up getting recognized both statewide and nationally as having recognized a way that we have been protecting our citizens' civil rights. So it's a case that I think really exemplifies the way in which our system works very well. The other two areas, really quickly, that I'll cover that we do in addition to the adjudications is, as it has been mentioned, we do provide clarifying regulations on the FEHA and other civil rights laws. Currently, we have pregnancy regulations that are going to be filed this month with the Office of Administrative Law to begin rulemaking. In addition to that, we have a completed set of disability regulations that will be adopted at our next commission meeting on March 30th. And then finally, we have housing regulations, a draft of which the commission will consider as well at that meeting on March 30th. So we are busy with those as well. And finally, public outreach. Although I can't say that I spoke 80 times last year, I'm not quite that energetic. Between Ann and I and a couple of the other commissioners, we certainly have been out there trying to educate both employers and employees and plaintiff and defense counsel on these areas. Thank you very much again for the opportunity.
Thank you very much. Ms. Doyle.
In the interest of time and because we would love to answer your questions, I'll keep it very brief. I just want to add a few things to what Commissioner Perez had to say. I'd like you to keep in mind that our resources are approximately $1 million, so that's what our budget is. We have 3 administrative law judges. If you count me, I'm the executive officer, and I've been in that role. We did have an unfortunate staffing issue last year, which has now been resolved. Our commissioners have stepped in. We had the services this year of a volunteer attorney, the economy, ironically, working in our favor. And we're very aggressive about recruiting law students to assist us. And so that's what we've patched together. We're working on 3 sets of regulations. We've handled every accusation brought to us by the department and adjudicated the cases that needed to be adjudicated. And it is a testament to the dedication of our staff and commissioners that we've been able to accomplish that with the resources available to us. In addition to what Commissioner Perez talked about, we have posted information on our website to help employers. We take calls from employers every day. We have a wonderful secretary who knows a lot, who takes the initial calls, but all of our legal staff takes these calls, and they're very useful both for the public but also for us because we learn what people don't understand, and it assists us when we're working on rulemaking. With the Department of Fair Employment and Housing, we've established through the State Bar a fair housing public accommodation section this past year and done several trainings with that section. And the department and the commission are now working on a practice guide for practitioners in this area. There's never really been one in California. And so with that, I'd be happy to answer any questions.
Very good. We'll have questions as soon as our last panelist has completed her testimony. Ms. Zuniga.
Laura Zuniga with the State and Consumer Services Agency. Thank you for the opportunity to appear today, and thank you for having the hearing and for your interest in this issue. I think, though, in the interest of time, I will just state that we're going to continue to work with the department and the commission to make changes. They're making a lot of improvements, doing very good work, and we'd be happy to continue to work with the committee and then with the department and commission to make further improvements.
Thank you. I'm going to begin with a couple questions and turn to colleagues as well. We've heard in many ways, first of all, again, I want to underscore statements made at the outset that I think the department has made tremendous strides, and I think all of us acknowledge that. It's in the spirit of trying to be as constructive as possible that I want to highlight what was really kind of a stunning difference between the presentation we just heard from everyone here and Mr. Blasey's presentation, which highlights a meaningful critique of the department and while acknowledging tremendous improvements in it. And so I want to just put this question broadly to members of the panel and see who wants to respond. You know, one of the elements in the Mr. Blasey's report, one of the, I suppose, the takeaways of that report is his statement that the existing system provides little deterrence to low-wage industries when handling their relationships with their employees, and little protection to low-wage workers. Pretty clear statements. I understand Ms. Perez's anecdote goes precisely to that, her example goes to that point. But I'd like you to respond very directly to the challenge of Mr. Blasey's report in this regard. What do you think? Is that critique inaccurate? It's a pretty important question for us to ask, particularly given the structure of California's economy at the moment. bottom line, are low-wage industries deterred effectively from engaging in unlawful practices, and are low-wage workers adequately protected by the system that you oversee?
I'd certainly like to give you my perspective. I can't speak for the private bar, but I can speak in terms of how we analyze our cases. And in the employment sphere, we don't focus on how much the employee made. If you look at why there is a difference in outcomes, in my opinion, it's because we don't focus on how much an employee made. We are going to bring a cause case regardless of the employee's level of income. It's one of the things why I like what I do so much. I want to bring justice to someone regardless of how much they make. That's what DFEH is all about, and that's what we're going to continue to be about.
Do others wish to comment?
You know, I think one of the reasons that I introduced myself at the beginning in terms of my private practice, that I work both in California and around the nation and sometimes internationally, is that though not perfect, because no system is, one thing that I'm very proud of in terms of working within the system is that we really are and continue to be, and I think will continue to be, a model nationally and probably internationally in terms of what we do. So I think that the recognition is that the current system, at least from the legal perspective, the court perspective, is that there probably is some disincentive for plaintiffs, as Professor Blasey pointed out, for them to take some of these cases because the damages awards are realistically not going to be high enough for them to take. I think that fact underscores in an even greater way why our administrative system is so important and needed. To the extent that that is the reality, the example that I gave you, and in the short time that I've been on the commission, I can give you 2 or 3 others involving farm workers, involving other low-wage workers who have other challenges in addition to their low wages, monolingual, low education, other areas or other aspects that make them probably not the most attractive plaintiff. It's one of the reasons that I certainly am so proud to be a part of the system is, as Mr. Muscat just said, that's not really an issue with what we do.
Yeah, the question isn't whether it's important and needed. We all agree. And I think, speaking for myself at least, I've recognized the relative paucity of resources within which you have to function with. Very little money, huge potential. There are 16+ million employees in the state of California right now, and that's a real issue. The question is, are we devoting our scarce dollars to their highest and best use as effectively as possible through the work that you do? And how can we help you to create the conditions for success where there is a need to improve still further? That's the spirit of this. Mm-hmm. So having said that, I mean, maybe that's all we're going to get today, and sort of the point-counterpoint of this. But I'm troubled by that because I think we can probably do better. Tell me more about either the current system is adequate to the task, there are enough resources, we're doing well, or there are at least some issues with which we need to contend right now that the legislature can assist in effectuating. Let me turn and ask you a question similar to what I asked Mr. Blasey. If there were 1 or 2 key things as an agency that you need to be most effective that you don't have, what would it be? What would they be?
Well, we focus on two issues. One would be training of our own staff as well as training of the public. And the other one is doing more mediation so that we don't even start with litigation. And we are moving into mass media to try to do more training. With these employment roundtables, we're trying to outreach more. In fact, it's significant that even though there are not very many plaintiffs' attorneys in the Central Valley, for example, Bakersfield or Fresno, these are in fact the department's best offices, most productive offices. In fact, I'm going to Fresno tomorrow, and I'm going to Bakersfield the day after that to outreach to employer groups so that they are abreast of the law. So we are using technology. We're doing outreach to do training. We continue to do public education through mass communications, which is actually how most people communicate today. And finally, we are hiring in-house mediators so that we can settle cases more quickly and more effectively at the outset, both pre and post-accusation.
Okay. So let me conclude my questions with this. My bet is that if there were to be a bipartisan consensus about the services you perform, that it would at a minimum be around the issue that you just identified that Senator Corbett talked about earlier, and that's the education that's preventative of employers. because that way we avoid all kinds of bad consequences for people, and the sort of system has to spend less money. You've indicated that you might benefit from enhancing that element of what you do, notwithstanding all the outreach that you engage in. Quantify that a little bit. What is the difference between the demand that you see that would really make an impact on diminishing the likelihood of discrimination and the resources you have now? What do you need? What's that delta look like? Are you prepared to do that today?
I'm not prepared to give a monetary amount.
Or a number of trainings. You do X number of trainings now, and you'd like to be able to do Y number of trainings.
Well, we did 200 trainings last year.
Yeah.
That was a lot.
Right.
And we certainly can try to keep that up. But in terms of electronic outreach, we reach far more people than that. I mean, on our YouTube site, we have over 9,000 hits. Facebook, we have a lot of people following us. Twittering case law alerts, we're reaching a lot of people that way. So with technology, I don't know that it really costs that much to do additional outreach and training.
Okay. All right, please.
I'd like to add to that from the Commission's perspective, because the Department's really the prosecutor and we're the adjudicators, so we have slightly different perspectives. It would be, I would echo what Director Chang had to say about mediation, both initially at the complaint process, but then very aggressively at before hearing. A lot of resources go into doing an administrative hearing, and even though the Department does a very good job, there are more cases that could settle with just more resources for that. So that's number one.
There's a handful of hearings, right?
Yes, but some of them, as a judge who's hearing the case, I think someone needed to get that employer and tell them, boy, you need to pay more attention to what's at stake here. Another area where I'm hoping that we can devote resources is to posting more things on our website that give employers a list of what they need to do, whether that's posters, so that there's an easy place that you can go as an employer, especially small employers, and know what your obligations are, the kinds of things that you need to worry about, some simple stuff about what the law is. I noted years ago when I went to we were setting up our website, Oregon had, if you want to go into business in Oregon, here's what you need to do. And it was like one website, and you could just click on forms and pull it all down. It made it really simple. And something like that would be great in California. It's just, we haven't gotten around to it. It's a goal of mine. We're putting stuff up on our website as we can. But that kind of putting information out there for every employer in the state, it just, as Director Chang says, putting things on your website, it's an inexpensive way to go. It does require some staff resources, but that is something that we would like to do.
Thank you. Senator Corbett.
Thank you very much, and let me also echo the remarks of the co-chair here that we certainly appreciate the work you're doing and understand the conditions under which you're doing them. But of course, we're always striving for ways to do things better, just as you are. So let me just ask a few questions following on the comments that you have just made with regard to additional information made available to employers, and we certainly applaud your work in addressing these needs through new technologies. How would we then, maybe some suggestions either today or in the future, and how we act more proactively to make sure that employers that may have some challenges with regard to understanding the needs that they should address, get that information. It's great to have the information for those that are going to do the right thing and go look up and see what the rules are and see how they can improve the way they do business with their employees. But there are those that might not even think to seek out that information. So what ways how can we be more proactive to address maybe repeat offenders or those that we know may have some challenges or some issues with regard to taking care of their employees in the way that they should?
Well, one thing that the department's really done a great job on is in cases where they've issued an accusation or issued a complaint, the department has done a very aggressive job on affirmative relief, requiring training, requiring companies to come up with new policies. The department's asked for that relief, and the commission has ordered it, and followed through with making sure that the order was enforced. So in that regard, I think it's been very effective. And I'd also say, from the trainings that I've gone to that the various employer roundtables have put on, especially someplace like the Valley, they've often been the only training that's available there for employers on how to comply with the law, and the department's been very aggressive in providing that training.
Great. And then
We
I
have
a couple-
outreach to
I'm sorry.
rural communities as well. We go to all kinds, for example, farm workers. We have outreach projects to Salinas and parts of the Central Valley and the agricultural areas in San Diego County and in the Inland Empire. So we actually have retired annuitants who do that with us and outreach into all these communities. Last year, we partnered with, we didn't just go out and give speeches, we actually partnered with about 160 groups. We didn't have the resources to put on conferences ourselves, but we became the embedded program in other people's programs, and many groups adopted the theme for the entire year. So it was a great deal of exposure, and I know the Chamber of Commerce is here today, and we certainly would be very happy to partner with a group like that to outreach to employers, large and small. We have the resources, we have the materials, we have the videos, we have the know-how, and we're willing to go there to do it.
Great. Thank you very much.
And if I could just really quickly,
Yes.
on behalf of the Commission, but also, again, as the chair of the Labor and Employment Law Section for the State Bar, and the department has been really good about this as well. In fact, the State Bar did, in part, fund the UCLA RAND study as a result of a grant request. So another way in which we are really collaborating all of the stakeholders is by figuring out creative ways of educating the public. And so we've actually given a couple grants to the department, the State Bar, so that this education takes place. On the Commission side, I think one of the things that frankly is extremely exciting, and not to pat ourselves on the back too much, but I'll talk about the others, not just myself. 3 commissioners were appointed, 3 of us were appointed at the same time, and we've got 2 who are experienced. The word that I keep using for both the department and the Commission is that there's this reinvigoration. We just are all so excited. I hope that it's palpable how excited and passionate we are about what we do. As a result, and the 3 people who were appointed, along the other 2 along with me, to round out who was already there, we're all employment law experts. We all have expertise in this area and years of experience. We've all gone out and done everything from speeches to collaboration so that we can do this education. On the staff side, certainly on behalf of the Commission, an exciting thing for this year is we will go from being understaffed as a result of things that were out of our control with only 1 ALJ to 3 this year. So I'm really excited that this year both the department and the Commission are going to be able to continue to work together to do even more than what we've been doing in the past.
Well, that's great progress. Thank you very much. I have 2 other specific questions that, during these times of, non-sufficient resources that have been floated that, affect the amount of resources available or the costs of providing this important service. One was a recommendation from the report that would allow DFEH to bring civil actions directly in Superior Court and collect attorney's fees. I'd like to have your comments on that proposal.
I think that if you could see my costs and benefits, it really goes and cuts into the benefit column for people in our system, because we've just become another part of the private bar, and we would start picking cases not only for their merit but also for their monetary value. We would have a vested interest in getting attorney's fees. So I think that you would actually have an opposite effect of losing the low-wage workers, minority groups, women may in fact lose out on a system that currently provides that safety net. So I would be very concerned before we went and said that we thought that was a good idea. Certainly, there are agencies that do that, but I don't think that we've studied it enough. But my primary concern is conflict of interest.
Mm-hmm. You don't think it would expand your ability to do even more?
The only thing I was going to add to that, and I say this just because I always sign the cost bills, our average cost of cases before the commission is dramatically lower. We get to hearing sooner, there's less discovery, there's no law in motion, as opposed to when we go to civil court, our costs are dramatically higher. Last time I looked at it, the difference was we spent about $5,000 in costs in a commission case versus $10,000 to $15,000 in costs in a civil case. So if all of our cases went civil, that would have a negative impact on our budget.
Mm-hmm. I don't think the proposal states that they should all become civil, but that there just may be that option. So something to take a look at and determine whether it's a good thing to do or not. And then the other suggestion by the governor's office that I thought you might comment on, because it's part of the report, actually, that would be important for us as legislators to know what your response is to relocating your work to the Department of Labor and Workplace Development, which also has administrative enforcement agencies responsible for workplace and labor issues. What are your thoughts on that? Because at some point we will probably be asked to address that.
I know that was a recommendation in the California Performance Review, so we're going to go back and look at kind of the history that went into that and the reasoning and a little bit of the feedback that came from it. So we'll do some more discussions internally with Labor and Workforce Development and with the Commission and Department and see if that would be appropriate. So we'd be happy to work with your committee as we move along looking into that.
No thoughts on it at this point?
I haven't had a chance to discuss it with the Labor and Workforce Development Agency, so I'd like to do that before providing any official feedback.
Okay, thank you very much. That's all my questions.
Thank you. Mr. Tran and then Mr. Hagman.
Okay, thank you, Mr. Chair. I tend to subscribe to the apples and oranges analogy instead of an access issue, and I fully understand and appreciate, and I think all the members of the committee here, the responsibility and burden of what the Commission as well as the Department are doing, given the limited resources, and you are doing a complementary aspect of the work in terms of providing, and it's quite, it's almost counterintuitive in one's thinking, because basically you're handling cases that our private attorneys are not taking. The issue for me actually is efficiency and time, because in my dealings with FEHA is that sometimes it takes a very long, drawn-out process in terms of days and months to get a resolution or even a response, actually. So I'd like to know specifically more in terms of your resolution rate, in terms of the time, the time period when, for example, an employee filed a complaint on average, say 10 years ago or 10 years hence. Has that time frame been improved in terms of resolution, and how are you doing? What are you doing? Some of the things that you've already talked about in terms of the new technology to speed up or expedite some of these processes, but I'm sure there are other ways to do that as well.
My sense is over the past year, we're slowly improving in that area. I have to tell you, when I first came to the department a year and a half ago, we almost uniformly would file an accusation on the day before the statute of limitations was about to run. With our case grading system, we're trying to move the cause cases sooner, so we're trying to push the envelope, not wait to the very last day, and I think that we are slowly improving on that area, and it's certainly my hope and expectation that we'll continue to improve. But it is an area that we can and should improve on.
Thank you, Mr. Tran. Mr. Hagman and then Mr. Monning.
Thank you, Mr. Chairman. And I just had a couple questions. Originally, for the first and second presentations, there was an appearance that maybe there's a lot of people that don't have access or are underserved. But you testified today that basically you see everybody who sends in a complaint. Is that correct? Not everybody has a claim, but you actually address someone who has a complaint at this point?
Yes. We don't have any backlog of cases, and we complete the investigations for the ones that fall within our jurisdiction.
So the ones that may want to seek private counsel, go through the civil court process, generally, for us who work with attorneys all the time, there has to be a reasonable likelihood they're going to win the case and have some kind of payout. Otherwise, they would be going that route for the most part.
It's always an individual choice for the complainants, but we never discourage complainants. If they want to seek private counsel and get their right to sue letter, we absolutely tell them it's their right and they can do that.
However, on our online right to sue system, we are very careful to caution unwary complainants who just want to get their right to sue and then go find a lawyer. We tell them, please seek the advice of counsel before you opt out, because once you opt out, we will not investigate your case. So it pops out throughout the program. In fact, we work with the plaintiff's bar to ensure that there's protection for people so that they don't make this mistake.
And to follow up on Senator Corbett's question about getting access to employers. As a private sector employer myself, go through the different stages. There's different ways you get your license, either through the city or the county. You get your license to do your business. Could that be something that you could pair up with those entities to issue business licenses to say, have you checked out your website here and gone through the thing, and that could be something we could add to it. So that way no one really has the excuse not to seek out the website where all the information is there for what notices you have to put up, because it is every year you got to put up a new poster, you got to do all the rest of the stuff here, and that information should be checked out when we renew our licenses, our business licenses, wherever we get them.
That's a wonderful, innovative idea. I totally support that. And, I think that would be great if there's a way to work with some licensing group to guarantee that somebody, the business owners, can come onto our site. It will reduce litigation. It will provide them with a source of continuing resource if they have any questions.
We love it, too. It's a great idea.
Mr. Hagman, would you like to take a little applause lap around? Very good. Indeed. Mr. Money.
Thank you, Mr. Chair. In the interest of time, we do have another panel, so I'm going to make a comment that might lead to some feedback later, but I've been instructed we don't have the time now. I'm particularly interested in the mediation options, and if you have any data showing pre-complaint mediation outcomes, post-complaint mediation outcomes, and whether you are able to engage mediation panels in different counties where there's often volunteer mediation programs through Superior Court programs to enhance your capacity to direct people to mediation. I think one of the problems in these cases, there's often a real disparity between employers who may have attorneys and a complainant who hasn't been able to connect with a private attorney, and mediation by definition is a voluntary process. Have you been able to make it somewhat mandatory through your process? I know that's a bit of an oxymoron, but if an employer gets invited or instructed that mediation is the next step in the process, and again, I'm not asking for responses to that now, but I would be interested in any follow-up on the mediation front and how we as the legislature might be able to help if there's any law reform that would expand mediation options, particularly for unrepresented complainants. Thank you.
Thank you very much for that question, which invites a response. Do you have a date certain by which you'd like that response, Mr. Money? I'd encourage you to say yes and provide it.
Yes, within 30 work days, please.
All right. Very cool. Thank you, panelists, very much for your hard work and presentation today. And now back to Senator Corbett for the last panel.
Yes, thank you all very much for your good work as well. Our next panelists will be speaking on a broad array of perspectives from the point of view of the stakeholders. So I'll welcome up Mike Belote, representing the California Employment Law Council, Kyla Christofferson from the California Chamber of Commerce, Mariko Yoshihara, Political Director, California Employment Lawyers Association, Francisco Lobaco, Legislative Director of the ACLU California, and Dara Shur, who's the Director of Litigation Disability Rights California. Welcome to all of you, and unfortunately, we're down to the wire. That sometimes happens to the last panel, and I apologize for that. We had you originally scheduled for 25 minutes. That's 5 minutes each, but we may have to shorten that a bit. My apologies. But welcome, and whoever would like to begin first, please do.
I need to go.
You need to go? Well, in that case, Michael, you go.
Thank you, Siska.
Mr. Belote?
Another continuing example of cooperation. Madam Chair and Mr. Chair, members, Mike Belote for the California Employment Law Council. I'll be very brief. Obviously, we haven't had the chance to put in the time. This was a very thorough report that was done. I think the gentleman said 8,800 hours. We have had a few hours to review it and give you our thoughts. There are certainly things on which we would agree. There has been a notable change in the character of discrimination claims in recent years. This isn't to say that, as the first speaker indicated, that there isn't animus based on race or sex or age, but the types of complaints that come to our members are decidedly different. We have some of the largest class actions in the history of jurisprudence in the discrimination area, and they tend to not be so-and-so was told X. They tend to be an analysis of statistics based on promotion and hiring, where the litigation really revolves around a debate between experts on what does the data show, not what happened to any individual person. Again, not that there isn't offensive activity going on, but the character of litigation has changed. It's far less flagrant, intentional. It's far more systemic, at least with our members. I would disagree that the deterrence model has not worked. I have watched the admittedly large organizations in my client association spend hundreds of hours on teaching the status of discrimination and harassment law. And it's really all with one goal in mind, and that is to avoid litigation. This is a very diverse group of lawyers and HR people who spend dozens and dozens of hours going through the detail of rapidly evolving changes in the law. And the law really has changed a lot, especially in discrimination and especially on the disability area. So it isn't at all surprising that the trend that he talked about is up on disability claims, because the law is evolving in that area. And we're attempting to evolve with it and explain it out to our member companies how to comply with the law and avoid being sued, because the deterrence effect of being sued on some of these is just enormous in terms of the cost that employers incur. I think, along the lines of Mr. Monning, we think that probably there is something that could be done with respect to smaller employers to assist in the mediation level, because it is expensive for employers and employees and the state. But probably the idea of sending a whole new raft of cases into the civil system is not warranted at this time. It sounds like the administrative process is actually gearing up and responding effectively. Now, are the outcomes different? Of course they're different, and I think that would be expected. One would expect the civil litigation outcomes to be higher dollar, more serious, because of the weeding out effect of people seeking counsel. So it's not that, some of this is to be expected, I think, but I was actually heartened to hear the changes that DFEH and the Commission were talking about, their ability to respond quickly to the cases that come in front of them. But I would say, if you watch the California Employment Law Council and their educational events, you would be heartened by how much time and effort is spent now teaching discrimination and harassment law and retaliation and how to avoid a problem in those areas.
Thank you very much, Mr. Belote.
Madam.
I don't know how I did that, Mr. Belote. Mr. Lovaco?
Madam Chairwoman and members, Francisco Lovaco on behalf of the ACLU. Again, I will be brief. I did read the report. I read the entire report this weekend, and I thought it was a very impressive and troubling analysis of the affairs of the Civil Rights Department of the state. I've been listening here, and it seems like everything's working fine. I read the report to very clearly say the system is not working well at all. And I hope the legislature takes those recommendations and findings very seriously, because I've been here a long time, and I always hear that we have a reinvigorated department and commission to do all this great work. Why are people constantly complaining about the department, at least the civil rights folks, for years and years and years? So, I mean, great. I'm pleased that they're going to do these great things, but what the report indicates is that we've created a two-tiered system of justice for employment discrimination. We've created those who can afford to retain or hire a lawyer, and those that can't. and those folks have to use the administrative process. Those folks are disproportionately low-wage workers and minorities. And certainly our view is we're going to continue to utilize a state administrative process to help victims of discrimination who can't get private lawyers. Let's make sure it works. That the minimal $15 million that the state of California budgets for civil rights enforcement is wisely spent. And if not, figure out another system that works better. Obviously, we're not here to sort of figure out another system. I think Professor Blasey sort of spoke to that in his report. That said, the hearing came up pretty quickly. I have tried to reach out to some of the folks in the area to see what kind of recommendations they made. And let me just give you just a couple handful of them. I think the report speaks and some of the things that I think could be done to be helpful. And in two-part. One is funding at the state capitol. Suffice to say the DFEH is underfunded. But I think it's this comment that I've received, that simply relying on more funding for the department is not the answer. We think an important priority should be to fund and expand alternative sources to handle these cases, such as nonprofits and legal services attorneys. I think the report speaks to that. I think you all ought to take a good look at that. Obviously, that said, it's fair to say that the current caseload of 75 cases per consultant is inadequate to enforce the law. These cases deserve more detailed investigation measured by appropriate guidelines. Certainly seems to me, at least, that we ought to try to achieve the same levels for civil rights enforcement that we did recently for parole agents, i.e. reduces from 75 to 40. Should be just as important. Likewise, and this was referenced earlier, the fact that there's essentially no training for consultants and that they're not required to have any experience in civil rights and employment issues is just hard to justify. Upgrading consultant qualifications and training is important, again recommended in the report. Efficacy. Nobody really talked to this, slightly the department did, but to me, the most striking thing when I read the report, among other things, was the disparity between outcomes in the employment discrimination claims pursued through either the EEOC or the DFEH. Was startling to me. Why is it that 20% of the cases filed with the EEOC are resolved in favor of the claimant with a median settlement of $7,500, while only approximately 7% of DFEH cases are settled for a median claim of $4,000? There is some argument that they have different. Essentially, they're essentially the same cases. Now, there are differences in the systems, but to the extent there are differences in the systems, and we want to continue to use the administrative process, perhaps we ought to be looking at the model the EEOC has in terms of trying to get better outcomes for victims of discrimination. The recommendation, one of the differences, of course, is that the EEOC does have a successful mediation program. There's been talk about that. DFEH, to my understanding, no longer funds a program in employment discrimination areas. It used to do that. They rely on volunteers now. I've been told by, again, practitioners that this is a very effective program, so I would suggest you pursue that area. Likewise, the suggestion that DFEH attorneys should be able to bypass the FEHC and go directly to court, as you mentioned, Madam Chairwoman, we think would be a good idea. That's what happens in the EEOC. And finally and secondly, and nobody's really broached this issue, Professor Blasey mentioned this, but I haven't gotten an explanation as to why 50% of cases are being currently rejected at the initial interview. All the analysis in terms of outcomes are cases that have been filed, as I understand. A complaint that I get constantly, not constantly, but when I reached out for this, that I've received from practitioners is how DFEH improperly discourages people from filing charges and turn them away before they can preserve their rights. I'm told this has been an ongoing problem. The report itself indicates that no basic data is maintained in a manner that permits review for this rationale. And I think we have to sort of deal with this issue. It's an issue that I know has been spoken to me very, very often over the years. Finally, the suggestion, again, as mentioned otherwise, there's a suggestion in the report to convene a task force to explore alternatives, methods to combat employment discrimination. We think that's a good one. And to the extent that task force can actually accomplish something, we think it's a good idea. Thank you.
Thank you very much for your comments. Ms. Christofferson, would you like to go next?
Thank you, Madam Chair. Kyla Christofferson on behalf of the California Chamber of Commerce. I, too, will try to keep my comments brief. We really appreciate the intent of the hearing in terms of, and the report in terms of looking at the effectiveness of the DFVH and is it running efficiently, is it doing the role that it should be carrying out, and we think those are all valid issues to look at, and we appreciate that. I also appreciate the comments in terms of education and outreach, especially to small businesses. The California Chamber of Commerce actually spends a great deal of our time putting out publications and doing a great number of trainings each year geared towards employers, particularly small business, towards preventing harassment and discrimination. And so those are areas that are very important to us, and we've put a great deal of priority on in terms of education of the business community. As far as the appropriate role of DFVH, I would like to echo Mr. Berlot's comments in the sense that there is a great deal to review in the report, but just in terms of highlighting a couple of things that popped out at me, I think that for the employer perspective, speaking for Cal Chamber, the administrative process does serve a very important role, and we would not want to see the administrative process be undermined. We think it serves a very important role in serving as the step between the workplace and the court system, and there's a long public policy of the administrative arena as serving as a filtering of sorts, and the fact that the study indicated that 50% of cases that are, or claims that are filed with DFVH are processed administratively indicates to us that DFVH is effectively carrying out its role in that respect. And of the 50% of the cases, it looked like, and that was about 375 cases out of 1,000, it said that just about all of those, except for 40 cases, were either dismissed or settled at the DFVH stage. And so that also speaks to the DFVH is handling a lot of these administratively. In terms of whether there's a barrier to lower income cases, are those not able to proceed to court, one of the things that we've observed with the cases that do proceed to court is it's not so much tied to socioeconomic status or to whether somebody's earning low or high wages, but it does seem to be tied to the value of the particular case. And there's damages besides income that is recovered in court. For example, emotional distress damages, punitive damages. So there's lots of damages that are awarded in court that aren't tied to how much a person is earning. So we would go back to, we think that in terms of the contingency fee process, in terms of being able to find a lawyer, it is very much tied to the value of the case. And for those cases that are viewed as smaller, it's appropriate for those to be handled at the administrative level, and it's important for the administrative process to be there to handle those. And again, there's a real long public policy that the Supreme Court established favoring the exhaustion of the administrative remedies, and it is something that the federal system has done quite long too. So we would want to encourage that continue, and we agree with more focus on settlement and mediation at that stage as well. In terms of funding, we think that we'd be concerned about getting away from the general fund model. We think that in terms of funding, that funding for DFVH should be looked at in the context of all of the other agencies that serve to handle labor and employment functions. There's a number of different agencies that were observed in the report, such as the Department of Industrial Relations, the Labor Agency. All of those, I think, should be viewed in the context of general fund allocation, and I think that would be the appropriate way to look at that. So I'll just keep it short and end at that. Thank you very much for the opportunity to comment.
Thank you very much. And next we'll hear from Ms. Schur.
Thank you, Senator Corbett, and thank you to the committee for holding the hearing and for having me speak. I represent Disability Rights California, which is the agency tasked by the federal government with protecting the rights of people with disabilities in California. This discrimination is a very serious issue for the folks that we serve, and I don't think anyone here would disagree with that. I want to commend the department for some of the strides they've made with extremely limited resources, as we've heard. And in particular, I think we've been impressed with the attempt to focus the work on strategic and significant cases with a broad impact. But I do want to share Mr. Labaco's concern that the individual cases that come in the door also get appropriate attention, and we are equally concerned with that 50% rejection number. And in part we're concerned, as reflected in the report, that you're dealing still, even despite the department's attempts to fix it, with a undertrained, understaffed consultant level. And our experience on occasion when trying to assist an individual to proceed through the administrative process is that those consultants aren't familiar with new areas of the law, they don't understand or have the time to handle the complexities of those cases, they don't have enough tools to do the preliminary investigation to flesh out what might be the merits, particularly for people who aren't very able to articulate for themselves in the first instance because of language barriers or disability or whatever that they are being discriminated against. And so I just want to make sure that as we focus on the department that we keep in mind not just their very important role in making law and doing cutting-edge cases, but their role as a safety net to serve, as we've heard so eloquently, the people who are in rural areas and who are not able to get private counsel. We certainly would support many of the other proposals, and absolutely any creative ideas for providing additional funding to the department I think would be critical. The only other comment, I have some written testimony in here. It has some more specifics in it. I don't think it's necessary to go into them now, but I think in terms of any move of the department, while we aren't in a position at the moment to say which agency is best suited, I would keep in mind that they have a very different civil rights function than some of the other employment agencies, and that function is much broader than employment. It includes housing, it includes hate crimes, it includes public accommodations, and it's very important that their agency, wherever it is, be supported in the full scope of their civil rights work, and be independent enough to pursue what sometimes are not popular causes on behalf of people, particularly where there is still a lot of misunderstanding and very blatant discrimination as there is for people with disabilities, as noted in Mr. Blasey's report. Thank you.
Thank you very much. And Ms. Yoshihara?
Thank you. Mariko Yoshihara. I'm the political director for the California Employment Lawyers Association. CELA is a statewide organization of attorneys representing workers in discrimination, retaliation, harassment, and other sorts of employment cases. So our attorneys are very familiar with the FEHA and its administrative system. We'd like to thank the committee and the researchers for bringing attention to this very important issue. As the study points out, the landscape of employment discrimination has changed considerably since the FEHA was first enacted. So we think it's critical that we have an evolving statutory scheme and administrative system to address the changing issues facing employees in the workplace. To address the first issue of the disparity between those that go through private counsel and those that go through the administrative system. We believe all workers should have equal access to the civil litigation system. The study shows that lower wage workers who typically have potential lower damages may have a harder time securing private counsel, and we think there are several proposals that may help improve access to attorney representation. First, we support the proposal that would allow the department's legal division to go directly to court rather than going through the commission. We'd also support encouraging the formation of nonprofit firms that may be better equipped to take smaller cases to court. And in fact, there are a lot of CELA attorneys that work for these nonprofit firms, and they are a successful model. As the study points out, that in order to sustain such an expanded model of enforcement and access to the court, the department or these nonprofits would need to be able to collect attorney's fees. Similarly, in today's system, in order for private attorneys to take on such smaller cases, they too must be insured recovery for the expenses of litigation. And recently, the California Supreme Court ruled in Chavez versus City of Los Angeles that in FEHA cases that might have been brought in a limited jurisdiction superior court but were litigated to a verdict of less than the $25,000 in an unlimited jurisdiction case, that the court may deny attorney's fees to the prevailing plaintiff. As the RAND study points out, any attorney who considers accepting a case that may result in a verdict under the jurisdictional amount risks being paid nothing at all, even if he or she prevails at trial, based on his or her inability to predict a jury verdict. A lot of times these cases involve emotional distress and special damages that are harder to predict and harder to quantify. As the Court of Appeals noted in their decision to award attorney's fees, even a modest financial recovery can serve to vindicate a substantial legal right, and that denying attorney's fees would discourage attorneys from taking meritorious cases. And obviously, the rights afforded under the Fair Employment and Housing Act are substantial legal rights. So we feel our legal system must be set up so that our attorneys can take on smaller cases without the fear that it may cost them their practice. Another option would be to specify that all cases brought under the Fair Employment and Housing Act are unlimited jurisdiction cases. That way there's not this gamble for attorneys who are faced with a case that may or may not have damages that are less than the $25,000 jurisdictional limit. In response to improving the alternatives to the civil justice system, CELA supports efforts to create a vigorous and robust administrative system through the department and the commission. We're very supportive of Phyllis Chang, and I think she's done a tremendous job, and her testimony was very impressive. But our attorneys do echo many of the concerns and issues that were raised in the study as far as efficiency and effectiveness of the current administrative system. We think that strengthening the training of the FEHA caseworkers should be a top priority. We're also very concerned with the tremendous caseload that the consultants are responsible for, and each case should have appropriate attention. Structural changes should also be a top priority. We would support moving the DFEH and the commission from the Consumer Services Agency to the Labor and Workforce Development Agency. And obviously increased funding is critical, and we would like to help come up with creative sources of funding that don't burden workers and also promote the spirit of the Fair Employment and Housing Act. And I'll close with that. Thank you.
Thank you very much for your testimony, and we want to thank everyone who is here today to help guide us on this extremely important issue, especially in recognition of the 50th anniversary of the adoption of this very important legislation. I just have a couple of closing comments and/or questions for this panel, and one would be clearly, I think that from what we've heard today, another hearing is warranted on this issue. And definitely another hearing with regard to the housing part of DFEH, which we did not have an opportunity to include today because of all of the wonderful testimony we had on the employment issues. So I think that we can look forward to that. And I would very much like to hear more about, you probably don't have to answer this question, but I'd like to definitely hear more about this concept of whether people are being discouraged from entering the process of having their rights taken care of. That has been brought up by a few of the speakers. So if you have specific evidence on that, that's certainly something we should look further into. So thank you for your comments on that. And that's really all I have. Members, are any closing comments, questions?
Madam Chair?
Yes, Senator Hancock.
Weren't we going to hear comments from the public?
Yes, absolutely. I was going to move to that next.
Oh, you were going to move to that next?
Yes.
Okay. Let me just say this has been a new topic for me, and I'm sorry that I had some meetings that meant I had to be gone for part of the time. But I feel like I have gotten an overview, and it's a very interesting and eye-opening one from the broad outlines of the problems of access and vigorous pursuit of people's rights. And we'll be very interested if there are suggestions for solutions, concrete selections that the committee could look at in a time of financial crisis for the state. How do we preserve these public structures, and our court system is one of the most important of, so that our people can be supported and move forward with their lives. So thank you all. It's been very interesting.
Thank you very much,
Madam
Senator
Chair,
Hancock.
I just have one very brief question for the panel. To the
Please,
extent
Assemblymember Tran.
Thank you, Madam Chair. To the extent that the panel members can answer, I think we can agree to a certain extent that the state government or the state agencies' administrative process has been overburdened with a lot of cases. I wondered, and this has not been touched upon, and that is public law centers and nonprofits, including the ACLU. Have you taken cases, and under what circumstances? I know that you do.
No, we generally don't handle individual employment discrimination cases. That's not our call. Right. That's if we handle these cases, it'd be class actions. But folks like the Employment Law Center, there are some organizations, I believe, that handle individual kind cases. And one of the recommendations that the report does make is that we ought to be looking at funding those kind of cases so that those individuals, especially for the lower wage workers, have an opportunity perhaps with some of the fee shifting ideas that suggested.
And we have actually through the IOTA funds as well as other types of funds. So because that aspect has not been touched upon, because some of these cases spill over, whether the private lawyers don't take it, and then you have the nonprofits can come in and help out as well.
All right. Thank you all very much for your testimony here today, and I'll excuse this panel, but would very much like to hear if we have people here from the public who would like to comment. If you could please come up. Anyone interested in testifying, please come forward. And I'm very sorry, but if we can keep our comments concise, and I know you will, we would appreciate that. But we're very happy to have you here. Mr. Kim, would you like to begin?
Madam Chair and Senators, Doug Kim with the California Applicants Attorneys Association. I only have one brief comment on the issue of transferring the department from Consumer Service Agency to the Labor Agency. I would just point out that the Labor Agency is charged with enforcing labor laws, occupational health and safety laws, workers' compensation laws, and those are far different from discrimination laws. The governor's proposal in his performance review, when he talked about reorganizing agencies, you might recall that he suggested the dispute resolution functions of the OSHA Appeals Board, the Workers' Comp Appeals Board, and the UI Appeals Board should be combined in a single entity. And I think many people pointed out at that time that even those involve wholly separate and discrete bodies of law, and it would just be administratively too cumbersome to do that. So we think the proposal to shift the agency to the Labor Agency would just be unworkable. Thank you.
We appreciate your input on that. Thank you very much. Mr. Dolan?
Madam Chair, members of the committee, thank you very much for taking the interest in this issue. I'm here today as the president of the Consumer Attorneys of California, but also I'm a practitioner in this field of employment law. And there are a few questions that were raised I'd like to address briefly, but I'd like to make my commitment to you on behalf of our organization and myself personally to help you work on this issue. My office screens 2,000 DFEH cases. My office. I have 4 lawyers dedicated to this work, which I understand now is half of what the state dedicates to the work. I know this work. I can tell you the 50%, why are only 50% accepted? I'd like to answer that question. Some of those 50% belong in the unemployment office because they simply don't have a case, but they call Fair Employment and Housing because the word fair is in the name. We get those calls. We provide them access to the unemployment office to help them collect their unemployment benefits. Additionally, private lawyers are doing pro bono service. My lawyers spend on average 10 hours per week counseling people on what to do with their employer to avoid it getting to a legal action. And I think that's an area in which the website of the DFEH does great work. It tells you what are your rights and what to do and how to address the situation so that maybe it doesn't encumber the system. As to the issue of the low-value cases, because I've heard that as being an issue today, this is important to note that this statute is unlike many others. it has a private attorney general function to it that allows lawyers to collect attorneys' fees to pursue the important public interest of the civil rights, even if the value is low. Low is an unusual statement, as it's been quantified by the statisticians here as being the wage loss component. I know, because I am the lawyer who has the most significant civil rights verdict in the history of the state of California without a single dollar in economic loss, because we advocated a civil rights issue without a dollar. It would be considered a low-value case by the criteria used. It was the largest award in U.S. history because of the right that was violated. Lawyers are taking these cases. They're taking them because there's an attorney general fee statute, in essence, a private right to collect attorney's fees when you have vindicated an important public right. The other reason why the lower value cases may not be taken is because those entities are not solvent, especially now at this economic time. If Jim's Garden Service has violated the law, Jim's Garden Service may not be there tomorrow. No entity, myself, private or public, will be able to recover from that entity. There are many explanations to your questions. There is limited time. I stand committed personally and on behalf of our association with the very viable and important California Employment Lawyers Association, of which I'm a member but not here on behalf of today, to work with you to also find ways to fund education, which is key. Thank you for your time and attention to this important issue. I look forward to working with you to help preserve the rights of Californians.
Thank you very much, Mr. Dolan. Ms. McGovern, how are you today?
Fine, thank you. Good afternoon. I'm Beth McGovern with the California Commission on the Status of Women. First, we'd like to thank the Department of Fair Employment and Housing for all the efforts being made, and specifically to thank Director Chang for all her good work. And thank you so much to the committees for holding this hearing today. We are very much in favor of finding ways to prevent discrimination and enforce anti-discrimination laws without victims needing to file lawsuits. And I say that in large part because women and people of color do have less ability to litigate, have less access to the system. I also say that because employees, for the most part, really don't want to litigate. They want the problem solved and be able to get back to work and do their jobs. It was mentioned more than once here today that the nature of discrimination is often very different today than it was in the past. And I'd like to take just a minute to briefly mention two types of discrimination that exist today that are not covered under current law, and both of these mainly affect women. The first is discrimination based on family caregiving responsibilities, and this is a very real type of discrimination. It's been recognized by the EEOC and in a number of other states. And the second is discrimination against victims of domestic violence merely because of their status as DV victims. So I'd like to urge that any changes that are being made be made with an eye toward recognizing and better protecting and serving victims of more current forms of discrimination, like family responsibilities discrimination and discrimination against victims of domestic violence. Thank you.
Thank you very much for your comments as well. Anyone else wish to address us this afternoon? Any additional closing comments, members? Thank you very much. I'd like to thank the members that were here today and for their important questions and suggestions. Thank you very much. You won't mind if that gets stolen. Very good. And of course, I want to thank the wonderful staff of both committees for putting together this very, very important hearing this afternoon and putting together the list of speakers who were very, very enlightening. And thank you all for your very important work. As I mentioned earlier, I think clearly as a result of this hearing and what we heard today that there's probably a need for an additional hearing on some employment issues and, of course, housing issues under DFEH. And I think it's very important for us to continue the work that we are doing in this legislative session to perform the very important duty of oversight on laws that have been passed and continuing to review whether our work is actually taking place out there in the real world and protecting those who we seek to protect in passing these laws. So let me just thank all of you for being here this afternoon, and I'm sure I will be seeing many of you in the future as we continue this work together. Thank you all very much. The meeting is adjourned.